go to Estafa. Estafa, whatever be the kind of estafa, whether it is under Article 315, estafa or swindling, 316, other forms of swindling, 317, swindling a minor, 318, other deceits. There are two general elements of estafa. First, that the offender defrauded another by abuse of confidence or by means of deceit. And second, that damage or prejudice capable of pecuniary estimation is caused to the offended party or to a third person. These are the two general elements of all kinds of estafa. The first one requires that there must be defraudation. And the said act of defraudation must be done either by means of abuse of confidence or by means of deceit. The second element requires that there must be damage caused. The damage caused must be capable of pecuniary estimation. Reason is, the penalty in estafa depends on the amount of damage caused to the offended party or to a third person. Hence, the damage must be capable of pecuniary estimation to determine the corresponding penalty. Under Article 315, there are three ways of committing estafa. 315.1, estafa with abuse of confidence or unfaithfulness. 315.2, estafa by means of false pretense or fraudulent acts executed prior to or simultaneous with the commission of the crime. And under Article 315.3, estafa through fraudulent means. X is engaged in the selling of jewelries. Why learned? X has many jewelries and he was engaged in the selling of jewelries. And so I went to X. He wanted to earn. And so Y told X, would you entrust me to sell your jewelries on commission basis? I will be selling it with commission. The price of the jewelry goes to you, but the added price shall serve as my commission. It was a good proposal, and so X agreed. And so X entrusted to Y jewelries amounting to almost $1 million pesos. And then thereafter, based on their agreement, Y is going to sell these jewelries for a month. After a month, Y has to return the jewelries to X. These jewelries which were unsold must be returned by Y to X after a month. And those jewelries which had been sold, Y has to remit the proceeds of the sale. That was what was stated in the said agreement. So, X entrusted about $1 million worth of jewelries to Y. A month after, no return of jewelries coming from Y, no remit of the proceeds. And so X called on Y. Based on our agreement, you have to return the jewelries that are unsold, minus your commission, and also you have to remit the proceeds. Where are these now? But Y said, I will just buy your house one time. Days passed. There was no payment. There was no remittance. And so again, X called on Y, but still, Y just kept on promising without returning it. And so, X wanted to file a case against Y. He went to a counsel. If you happen to be at counsel, what would be your advice? What case may X file against Y? X may file a case of estafa under Article 315.1b. Estafa through misappropriation or conversion. X entrusted these jewelries to Y on commission basis with the obligation to return the unsold jewelries to X. Despite demand, Y failed to return the same. Therefore, X will be liable for estafa under Article 315.1b. When X transferred the jewelries to Y, what X transferred to Y was the juridical possession of the said jewelry. During the period of 1 month that X gave to Y to sell these jewelries, Y has juridical possession of the said jewelries, Y has even a better right even than that of the owner. Juridical possession is a possession in the concept of an owner. It is a legal right over the property which has been entrusted to him. So, since he failed to return the same, he will become liable for estafa through misappropriation or conversion under Article 315 1B. But what if the case was filed? The argument, here comes why. Why said he should be acquitted of the crime charge. According to him, one of the elements of Article 315 1B is demand. And according to him, he did not receive any demand coming from X. There was no demand letter. Therefore, one of the elements is absent, he cannot be convicted and held liable of estafa through misappropriation or conversion. Is this argument correct? The argument is wrong. Supreme Court said, under Article 315 1B, demand need not be a formal demand. Whatever kind of demand, whether it is oral, phone, it is considered already as demand. Formal demand is only required in estafa through postdating a check under Article 315 2D, but it is not required in estafa through misappropriation under Article 315 1B. The fact that X code Y, 2 times, 3 times, asking for the return of the jewelries, asking for the remittance of deposits, that is sufficient demand. In fact, Supreme Court said, demand is not a material element of estafa through misappropriation because if there is evidence that this offender already take away the said property, demand is deemed present. So demand is any kind of demand or it may be absent in case of estafa through misappropriation or conversion. X sold a piece of land and X went to the bank and deposited the amount of 20 million. The amount paid to him for selling the said piece of land. And X was in a hurry because the seller was there or the buyer was there and they have still to arrange certain documents. And so because of that, X told the clerk, the bank teller, at the bank, that he's going to leave his passbook as well as this 20 million cash placed inside a bag, and he instructed the teller to deposit this to his account. And according to him, he will come back after lunch. They just have to finish some documents and arrange some documents. After lunch, here comes X. He went back to the bank. He was looking for the teller on whom he had left the 20 million and his passbook. But the teller was gone. The manager gave the passbook to him, and when X looked into the passbook, the said 20 million was not deposited. And so, he wanted to file a case against the said bank teller. What case may he file against the said bank teller? Should he file a crime of estafa or should he file a crime of theft? He should file a crime of qualified theft and not estafa. It is qualified theft and not estafa because when X gave the 20 million to the bank teller, what he transferred to the bank teller is only the material or the physical possession of the said 20 million cash. Juridical possession remains with him. Therefore, when this money was misappropriated and appropriated by the said bank teller, the crime committed is theft, in particular qualified theft, because of the presence of grave abuse of confidence. There was a relationship of guardianship, dependency, and vigilance between the bank teller and X, the depositor. What if the client, the depositor, went to the bank and he withdrew money from his account in the bank? This was noticed by the bank teller who happens to be, who has always been close to this client. And the bank teller told the client, the depositor, instead of you bringing your passbook whenever you withdraw money, you can just leave your passbook with me. And that is exactly what X did. He gave the passbook to the said bank teller so that he need not bring it every time he would withdraw money. But on second thought, X went back the following day. He went to the teller and asked the teller, I no longer want to leave my passbook with you. Can I have my passbook? But the teller said, I'm sorry, I left it in the house. So, X left. The following day, again, he went to the bank teller. I need my passbook. Oh, I'm sorry, I still left it in the house. It is in the house. Tomorrow, I will bring it. I can give it to you. This, however, was noticed by the manager. The depositor always going to this particular client, and after talking, he would be leaving. So what is his business? And so the manager confronted the depositor, the client. What is your business with our teller? He told me to leave my passbook. Now I'm getting my passbook. He said he always left it in the house. And so, when the client left, the manager talked to the teller. Why don't you return the passbook of our client? I already gave it to him. Perhaps there was a misunderstanding. But the manager didn't believe. And so the manager conducted an investigation on the account of the said client. And based on the said investigation, it was found out that there were 3 successive withdrawals on the account of this client, 3 times on different dates. And based on the withdrawal slip, the manager immediately noticed that the signature of this depositor on the withdrawal slip is different from the specimen signature submitted in the bank. And it is also very evident in the withdrawal slip that this bank teller participated because he signed in the verification. And so because of this, the said manager secretly went to the house of the said client asking, are you the ones who make these withdrawals? But the said depositor said, no, in fact, that is not my signature. My signature was copied, but that is not my signature. And so, a meeting was set in the bank between the bank teller and the said customer or client. And the bank teller has no recourse but to admit he was the one who withdrew 3 times from the bank account of the said client. What crime or crimes had been committed by this bank teller? The bank teller shall be held liable for 3 counts of estafa through falsification of commercial document. It is commercial document because Supreme Court said the withdrawal slip is a commercial document. It is a document defined and regulated by the Code of Commerce. Why is it estafa? Why is it not qualified theft, not theft? Because this time, there is juridical possession of the said property because the said thing taken is the money already deposited in the bank. Supreme Court said, the person damaged here is not the client, but the bank. Because the bank has to pay the money to the client. Therefore, Supreme Court said, the crime committed is, since there are 3 withdrawals on different dates, 3 counts of estafa through falsification of commercial document. X, Y, and Z are now licensed. They are now licensed medical technologists, medtechs. They passed the board exam, and X, Y, and Z wanted to work in another country. X, Y, and Z wanted to work in Canada. They heard that medical technologists are needed in Canada. And W learned about this. And so W went to the boarding house of X, Y, and Z. And W represented to X, Y, and Z that he has the agency, he has the power, he has the qualification to bring X, Y, and Z to Canada. But of course, They have to pay placement fee, all of them in the amount of 100,000 pesos each, inclusive of everything. X, Y, and Z believe they really wanted to go to Canada. And so, each of them gave 100,000 pesos to W. Upon receipt of the money, W never came back. X, Y, and Z never left the Philippines. What crime or crimes may be filed against W? W can be held liable first for estafa through false pretense under Article 315(2)(a). Under Article 315(2), estafa by means of false pretenses or fraudulent acts executed prior to or simultaneous to the commission of the fraud, it is necessary that the said false pretense must be simultaneous in concomitance with the deprivation. Were it not for the false pretense on the part of the offender, the offended party would not have parted with his money or his property. And that is true in this case. Were it not for the false representation made by W, that he has the agency, the business, the power, the qualification to bring XYZ to Canada to work as medical technologists, X, Y, and Z would not have parted with 100,000 pesos each. Therefore, the crime committed is estafa through false pretense under Article 315(2)(a). Any other crime? A case of illegal recruitment in large scale can also be filed against W. Illegal recruitment in large scale is committed when the offended party, when illegal recruitment is committed against 3 or more persons individually or as a group. Here, the victims are X, Y, and Z. Hence, it is illegal recruitment in large scale. In your labor code, it is a crime involving economic sabotage and the penalty is life imprisonment. Therefore, it is a non-bailable offense. Whereas, estafa through false pretense is a bailable offense. These two remedies can be filed at the same time. They can be heard by the court at the same time. They are cumulative remedies and not exclusive remedies. One does not exclude the other. 10 persons form a new investment company. And after they have formed this investment company, they went to this certain community. And they were able to induce, incite the people in this community, about 50 of them, to invest in their newly formed investment company. They call these people and they promise to give their investment 6.5 interest and a return in total of the investment. And so because of that, the people were enticed. And so the retirees invested their retirement pay. Others borrowed, obtained loan just to invest in this company because of the high rates of interest. They were enticed and induced to invest. After giving their investment, these 10 men would give them a certificate showing the amount of investment, plus post-dated checks. Post-dated checks representing the interest every month for their deposit, for their investment. On the maturity date of the checks, these people deposited their checks, but all their checks bounced. No such account in the bank. And so what did they do? They sent demand letter to these 10 men in the address given. But their demand letter was returned to them, not received. No person living in the same address. And so they went there personally. And indeed, the said address, in the said address, there were no such people. There was no such name of people. And so, because of that, they consulted a council. They wanted to file a case against these 10 men. What crime or crimes may they file against these 10 men? They can file a case of syndicated estafa. Estafa is always bailable. The only time where estafa would be non-bailable is under PD 1689, that is in case of syndicated estafa. There is syndicated estafa when the following elements are present. First, that the offender commits any of the acts of estafa under Article 315 or under Article 316. Second, that the offenders are a group of persons consisting of a syndicate which involve 5 persons. And lastly, that the defraudation consisted in the misappropriation of money contributed by stockholders or members of rural banks, cooperatives, samahang nayon, farmers association, or money solicited by a corporation or association from the general public. These are the elements of syndicated estafa. All the elements are present in this case. First element, the offenders here, the 10 men committed estafa under Article 315 2A, estafa by means of false pretense, were it not for their representation that their investment company can give the return of the investment plus 6.5 interest, these people will not be induced to make such investment. Second, they are 10 persons. Therefore, they are a syndicate. The law only requires 5 to be considered a syndicate. And lastly, the money was solicited by this investment company from the public. They were about 50 people. They represent the public. But what if, in the same problem, these 10 men form an investment company? They were looking for investor. And they heard that W won in the lotto. W won 100 million in the lotto. And so these 10 men went to W, explained to W their newly formed investment company, and promised W 6.5% interest plus return of investment. W was induced. And so, what he did, he first invested the amount of 10 million. He was given a certificate of investment plus postdated check representing the profits. On the date of the maturity of the check, he deposited the check. It was a good check. He was able to get good profits. So, he was incited to invest more. He invested 20 million more. So now he has 30 million. He was again given a certificate of investment plus checks representing the profits. He deposited it again on the maturity date. Again, good check. So, he further invested. He invested 50 million more. And so now he has 80 million. Again, it was a good check when he was able to get the profits. So, this was a very good business. So what did he do? He invested the entire lotto winnings. He was again given a certificate of investment plus the checks representing the profits. On the date he deposited the check bounced. It was discovered when he sent demand letter. The said demand letter was returned. No person of such name in the said address, no such company. Too late, he looked at the SEC. There was no such company registered. He had been deceived. And so what did he do? He filed a case of syndicated estafa against these 10 men. If you were the judge, would you convict the accuser's charge? If you were the judge, you should not convict the accuser's charge. They are not liable of syndicated estafa. They are liable only of simple estafa under Article 315(2)(a), estafa by means of false pretense. The first element is present. These 10 men committed estafa by false pretense under Article 315(2)(a). Second element is present. They are 10 men, therefore a syndicate. But the third element is absent. The third element requires, according to the Supreme Court, that the money must be solicited by the corporation or association from the general public. Supreme Court said, the victim in this case is only one person. That one person does not represent the public. Therefore, Supreme Court downgraded the crime from the charge was syndicated estafa. Supreme Court said, he is liable only for simple estafa under Article 315(2)(a), in particular, estafa by means of false pretense. The accused, X went to Y, and X told Y that he needed construction materials for the house that he is building. He ran out of construction materials and the house must be immediately built. Y has this hardware store. But Y said, I only sell on cash basis. No cash, no materials. But X said, I needed it now. I need it desperately. I may not have the cash, but I have here a check. A post-dated check. I guarantee you on the date of the maturity, it will be funded. Y believed, Y took the check. And the construction materials needed by X were all boarded on his truck. X left. On the date of the maturity of the check, Y deposited the check. The check bounced. Y sent notice of dishonor to X. X failed to make good the check. Days, months passed. Still, X didn't make good the check. Y wanted to file a case against X. What case or cases may Y file against X? Y may file a case of estafa by postdating a check under Article 315(2)(b). Y may also file a case of violation of BP 22 against X. Y may file a case of estafa by postdating a check under Article 315(2)(d), because here, the false pretense in the issuance of the check was in concomitance or simultaneous with the debt violation. Were it not for X representation that this check will be funded on its maturity date, Y would not have parted with his construction materials. There was false pretense at the issuance of the check. Likewise, X can be charged with the crime of violation of BP 22, because for every check that bounce, violation of BP 22 is committed. Because the essence of BP 22 is the issuance of a bum or worthless check. What if in the same problem, X went to Y asking for construction materials, but X immediately told Y, I have no money now. Can I pay you a month later? Y said, no problem. Choose your materials. Pay me a month after. So the construction materials were boarded on the truck of X. A month thereafter, no payment was made. Y visited X in the house. X said, I have no cash. I have here a post-dated check. I guarantee you this check will be funded on its maturity date. Y accepted the check. On the date of the maturity of the check, Y deposited it, it bounced. Y sent notice of dishonor. 3 days passed. 5 days passed. The said accused, the said drawer of the check failed to make good the check. Y wanted to file a case against X. What case may Y file against X? Y can only file one case against X, and that is violation of BP 22. There is no more estafa this time. There is no estafa by postdating a check, because in this problem, X issued a check in payment of a pre-existing obligation. If the check was issued in payment of an obligation that is already existing, there is no false pretense that is present simultaneous with the debt violation. Hence, there is only a case of violation of BP 22. I need not discuss it. I'm sure it has been discussed by Judge Pimentel, the violation of BP 22. The third kind of estafa under Article 315 is estafa by means of fraudulent means. The first of this is by inducing another by means of deceit to sign a document. X is the son-in-law of Y. X is the son-in-law of Y. Y is very old, almost sick, and he could no longer see. It's everything. He could no longer read. Everything is blurred. But why the mother-in-law of X is very rich? Many properties everywhere. Among these properties, those in Tagaytay. And so X went to Y, and X told Y, the mother-in-law, the son-in-law told the mother-in-law, your properties in Tagaytay, the taxes had not yet been paid. The real estate taxes had not yet been paid. I prepared the documents for you. You sign it, and your real estate taxes will no longer have any problem. It will be paid. The mother-in-law believed. And so the mother-in-law signed the said document. But unknown to the mother-in-law, the said document is a special power of attorney, granting the son-in-law the power to sell her properties in Tagaytay. By means of deceit, the son-in-law was able to induce the mother-in-law to sign the document. Crime committed is estafa through fraudulent means under Article 315, 3A. We go to arson,